So this is going to be very light touch moderation. We're going to introduce Doug Allen here going first. He, as was mentioned, runs the Bellingham Field Office for the Department of Ecology, has been with the agency a long time and works on many different Department of Ecology issues. But I would hazard a guess his experience has been similar to mine, that water rights and water resources eat up a disproportionate amount of his time. Doug's not a lawyer, but like all Department of Ecology water resource people, they understand the law and the regulations and the history in many cases better than their own lawyers, and I was one of them, so I'm admitting that. And Doug is one of those folks, so let's bring up Doug Allen.
Back to the beginning. So I'm really honored and humbled to be able to talk at this event. I mean, there's some really smart, educated, qualified, brilliant people here, and so hopefully we can take advantage of that. So this is one of my favorite topics, is water, all elements of water. It's and something I've been dedicated to for about the last 35 years of my career. So, so what are water rights? The fundamentals of water rights. So I wanted to start with 3 questions. The first one is, in Washington State, who owns the water? Jay touched on this. Anybody? The people. Yeah, we all do. So water is a public resource. It's not owned by property owners. It's attached to land, but it's managed by the state on behalf of the citizens. Second question. So what does water have in common with time?
Not enough of either.
Good. A lot of good answers there, but the answer I came up with, for this purpose, is money. Time is money, water is money. So the right to use water is attached to land, and it can greatly increase the value of that land. Third question. To maintain a water right, you must use it or lose it. So the right to water use can be lost or relinquished if not used. Another fundamental, first in time, first in right. Jay touched on that as well. So the use of water in Washington is based on prior appropriation. So that means the first person to put the water to use has the right to continue to use the water. And Jay mentioned, let me get the arrow going. So the gold miners were the first ones to start using water on a regular basis in the West, and they used it to separate lighter rock from gold. And water rights are a common theme in Western lore, as Rex Allen proves in this action film, The Last Musketeer. And this is an interesting intro. The scourge of outlaws, Rex was. His 6 guns blazed the way for ranchers to keep their water rights. Pretty cool stuff. It's also got slim pickings, by the way, so it's got to be legit, right? So how do other states manage water? And so pretty much all Western states use prior appropriation. Most states manage groundwater, but not all. And one interesting exception is British Columbia. They do manage groundwater now, but it wasn't until 2015 that they started. California is also a latecomer. Most states have some form of an exemption for domestic use or other uses. So they asked me to summarize how other states do it. And that's it. It's really quick. So how do I get a water right? There are 3 main ways that we can do that. One is a water right claim, a water right certificate, or through the groundwater exemption. So Jay talked about how in the old days, before the water code, people claimed water rights. So prior to 1917, people often posted a notice on a tree or on a board somewhere near where they were diverting the water, and that was their water right. This is a really good example. It's from TWISP, and the date 1900, and they wanted to divert 2,000 inches for agricultural purposes. That would be irrigation, but that's the kind of stuff that they did back then. So this is a more recent water right claim. So with that old way of doing things, there got to be competition and conflicts. And so to resolve some of these conflicts, the Water Code was enacted in 1917 and established a new process. But eventually we wanted to have these claims documented. So in 1967 or thereabouts, the state encouraged people to register their claims. They'd fill out a claims form. And it has a lot of the same things that the previous one had. You know, they try to quantify the right gallons per minute, acre feet, the acres of irrigation, and a legal description. And with the passage of the Water Code, instead of a claim, now the new standard was a water right certificate. So I'll go over that a little more detail, but this is the second way to get a water right. And this is a good example of a water right certificate. It's pretty old too, but it's got the standard things we want to see. Volume, 132 gallons per minute, 40 acre feet per year, 20 acres. And the legal description. So everybody, a lot of you are familiar with that, the typical legal description, the quarter section of the quarter section, section 11, township and range. I know some of the mapping that our people have done have legal descriptions that are a paragraph that long. Pretty interesting stuff. So what's in a water right? So most of them have a priority date, and that gets back to seniority, and that gets back to first in time, first in right. Most of them have an annual quantity. We shorten it to a QA, an instantaneous quantity, cubic feet per second or gallons per minute. Place of use, point of diversion, purpose of use. Many purposes of use are beneficial: domestic, municipal, industrial, irrigation, power, livestock watering. So how do I get a water right today? It's a simple process. It's not easy, but basically you apply for a water right, you get a permit, you put in the pumps and the pipes or the diversion, you put the water to use, and if you've done everything right and you're lucky, you get a water right certificate. And when reviewing these permits, these applications for permits, there's what we call the four-part test. And so 4 main questions. Is the water available physically and legally? Is it a beneficial use? Does it impair existing rights? And is it in the public interest? And I forgot this. Oh, there we go. All right. So the third main way of getting right to use water is a groundwater permit exemption. So in 1945, as Jay mentioned, the legislature added groundwater into the Water Code, but made some small uses exempt from the permitting process. 5 minutes to go. I got to hurry. Can you change a water right? Answer is yes, but no part of a change can impair an existing senior water right, and only a portion of the right that's been put to use is eligible for the change. I won't go into that anymore. So in-stream flows, that's been a hot topic recently. It's always been pretty much a hot topic. And in 1971, the legislature passed the Water Resources Act, which gave us the foundation to establish in-stream flow rules. The Nooksack rules was established in 1985. Minimum flows for the Nooksack River and numerous tributaries, so that led to some restrictions and conditions for new water rights. Those would be junior to the in-stream flow rule. If I want to apply for a water right, what are my chances? It depends, but it's getting harder all the time, especially in Whatcom County. Why? A lot of reasons. More people, over-appropriation of streams, many more wells, and climate change. So then we come to a recent development, the Hearst Case, which complicates things even more. So that was in October of 2016. And my hourglass, oh, she's waved me off. I'm still going. Okay. So Ecology was not a party to the lawsuit, but we did file a friendly brief in behalf of Whatcom County. The case went to the PCHB, where Hearst won, then went to the Court of Appeals, where Whatcom County won, and then back to the Supreme Court, where Hearst won again. And what does it mean? It means that building applications proposing to use a private well must demonstrate that the withdrawal of water won't impair a senior water right, including in-stream flows. And although ecology is not a party to the decision, we've been trying to work with Whatcom County and other counties to help them figure out what it means and how to deal with it. And we have a couple of maps on our website that show areas where if you apply for a water right, you're probably not going to get one unless you can show that it's not impacting a stream or you can mitigate for that use. And as you can see, it's pretty much the whole county. There are some places. But there's going to be a lot more detail on that from other speakers, so I won't go into it any further. And so we have a website you can go to. We just refurbished it, so it should be flawless. And you can find whatever you need to find. But it is pretty helpful, and you can also call us at our office, which is a new number, 360-255-4400, and that's partly because we're moving our office soon, so we'll be on Squalicum Way in about a month. And so feel free to call us, and just remember, conflict often leads to opportunity. That's it.
Thank you, Doug. I think we're going to go through the presentations, and if we have time for Q&A. Okay. All right, so Bill Clark is next. He is introduced. He is a attorney and lobbyist for a number of clients down in Olympia. I find myself at times with clients who have different interests than Bill's, and my experience nonetheless is that he is super creative, really brings a willingness to look for compromise and look for solutions. He's as good at that as anybody I've worked with. It's a pleasure to bring up Bill Clark.
What I think I'll focus on is this. If I can give you one message to take away from what I'm going to talk about, it's that in addition to what Doug talked about and water rights, which people think are water you take out of the stream, there are water rights that exist in the stream too, and they emanate both under state law in the form of in-stream flows adopted by Department of Ecology, and they also arise under federal law in the form of enforceable tribal treaty rights to in-stream flows. They're both imprecise, but they are enforceable, and so that is one of the motivating factors, I think, to figure out a way to reconcile out-of-stream water uses with in-stream water uses like Jay talked about. To start with, I'm going to talk about the Hearst decision. As Doug mentioned, I think everybody up here is aware of it. Doug mentioned that under the water code, there are certain water uses that are not subject to the permit requirement. That's 9044-050, the so-called exempt well statute. It's not subject to the four-part test for new water rights, meaning when an exempt well, your typical kind of rural domestic well, is used, there is no permit review, right? There is no impairment test when that well is drilled or used. But keep in mind that exempt use is part of the prior appropriation scheme. That is, it still has a priority date relative to other water uses. And so even though it's not subject to impairment review, it can be subject to an impairment claim if it impairs a senior water right. Next statute to be aware of is for building permits. 1927-097 is part of the state building code. It requires local governments, when they issue building permits, to conclude that there's an adequate water supply, right? The term is different than impairment, and what adequate water supply has never really been well defined, but that's what became at issue in the Hearst decision. And then finally, 9003-345 is part of the state's water code. It says that when ecology adopts an in-stream flow level by regulation, it's a water right. It's just like any other water right within the prior appropriation scheme, and it has a priority date of the date of rule adoption. So combining those three concepts, since the 1970s, as ecology has adopted in-stream flow regulations, what county governments have done when they rely on ecology rules is they'll say, does this rule regulate exempt wells or not? The early rules adopted by ecology in the 1970s and 80s, under the thinking at that time that groundwater and surface water were not connected, those rules didn't apply to exempt wells. And so, for example, here's the Nooksack in-stream flow rule. It's like many of the rules in the Puget Sound basins. It establishes an in-stream flow level, but that level does not apply to exempt wells. It didn't apply to groundwater. It didn't apply to single private wells when they were drilled. The thinking in 1985 was there wasn't a connection between groundwater and surface water. That understanding has changed over time because of case law. What you'll note from this slide is, and this is, I just picked out dates, August 26th of the last 5 years, the minimum in-stream flow under ecology's rule, the minimum that should be in the Nooksack River at the Ferndale gauge is 1,900 cubic feet per second, right? That's what ecology believes is the necessary flow. The actual flow is listed. It's nowhere near meeting that flow, right? The challenge with in-stream flow law under state law is that flows are not adopted so that they will be met every year. The flow level that is adopted by the state is not a flow level that the state expects will actually be there each and every year. It's kind of a probability. The older in-stream flow rules, like the one in Nooksack, similar to Snohomish, similar to the Green River, the Sammamish River, most of the Puget Sound basins, it's about a 50% probability that flow should be met about half the time. But as you can see, it hasn't been met in any of the last 5 years. It wasn't met during 2017. And not only is it not being met, it's not even close to being met, right? Last year it was, about less than half. So the flow level exists, it's adopted, it's enforceable, even though it's not being met. What is the Hearst decision? The Hearst decision was about the county saying, when we issue building permits, we look to ecology's rule. Ecology's rule does not apply to exempt wells, even though the in-stream flow level is not being met, because ecology's rule that sets that in-stream flow doesn't apply to exempt wells. Water's available, right? So water's legally available, even though it's a junior use that could be impacting that in-stream flow. It stands for the proposition that when ecology adopts a rule, if it doesn't apply to the in-stream flow rule, counties cannot necessarily rely on those ecology rules, which is a big change in how things have been at the county level for the last 40 years. If you really look at what the case is about, you can ask, why is it that under the water code, exempt wells are not subject to impairment review, but then you have the Supreme Court saying under its GMA authority, it is subject to impairment review? And I think it's because the court didn't look at it in terms of whose job is it to review impairment. The court looked at it, as it has done with some prior cases, including one that Adam's going to talk about, that the court doesn't care who's reviewing these wells for impairment, somebody's got to do it. And an in-stream flow level is being established by the state, it's not being met, junior uses are still being allowed, and under the prior appropriation scheme, that's unlawful. So they were less concerned with whose job it was to review impairment, more concerned with the fact that impairment review has to take place. And here's the situation. These orange counties you'll see are the ones kind of like Whatcom County. They have rules that are similar to the Nooksack Basin rule. They have an in-stream flow level. That in-stream flow does not apply to exempt wells. So those are kind of the Hearst-affected counties, the ones within orange. I'm going to skip over that because we can get into questions later and touch on the other kind of form of in-stream flow water right that frankly is probably more powerful and more potent than state in-stream flows, and those are federal in-stream flows that arise under federal treaty law. This is an area of law that you cannot do justice to in 10 minutes, in 10 days, right? There's a body of case law that goes back half a century on this issue, longer than that in fact. So two areas of kind of tribal in-stream flow water rights to be aware of. There's a concept that when the federal government makes a reservation of land, whether it is an Indian reservation, a national park, a national scenic area, a military base, implied in that there's a reservation of water for the purposes of that federal reservation of land. So there's a term you'll hear, the so-called winter's water rights, which are construed to be on-reservation water rights to fulfill the purpose of that federal reservation of land. And so when an Indian reservation has been created, there's a winter's water right for on-reservation water use, right? And you look at the treaty to say what was the purpose of that federal reservation of land. If the reservation of land was a large reservation of land and the treaty and the evidence around treaty time shows that widespread agriculture was the purpose of that reservation of land, then there's going to be a large winter's water right for irrigation on that property. If you look at other treaties, you kind of look at what was the purpose of that treaty, and that defines the scope of the on-reservation water right. What's more probably powerful and more uncertain at this point in time are in-stream flow water rights off reservation that emanate under the Stevens Treaties, right? The so-called fishing clause under the Stevens Treaties is the right of taking fish in common with the citizens. This is the so-called fishing clause that's been at issue through the Bolt decision. The Bolt decision in this slide here is the fundamental concept that the availability of fish is allocated on a 50-50 basis between Indians and non-Indians. What happened after the Bolt decision was phase 2 of the Bolt decision, sometimes called the Orrick decision. Judge Orrick was the judge that replaced Judge Bolt after he retired. The Orrick decisions also in the 1980s implied that there was an off-reservation habitat right, that if you have a right to take fish in common with the settlers, implied in that is an environmental right to in-stream flows, because if there's no water for fish, there's no fish. Judge Orrick issued a number of decisions that were very strongly worded decisions creating, in essence, an in-stream flow habitat right, but that ultimately the Ninth Circuit vacated. Again, the history of this is fascinating. It bounced back and forth between the Federal District Court and the Ninth Circuit. Ultimately, the Ninth Circuit vacated this idea that there was an implied habitat right. The fact that that decision was ultimately vacated, I don't think matters much, because at the same time, other courts were dealing with this question of, is there an in-stream flow water right that arises under federal Indian law? And the answer is yes, right? There was a case from the Klamath Basin called Adair in the 1980s for the Klamath tribe that they had an in-stream flow water right for fisheries purposes. There was a case from the Yakima Basin that created the in-stream flow water right for the Yakima Nation, not just theoretically, but in an enforceable sense. As Jay mentioned, fish runs in the Yakima in the 80s went down to as low as I've seen 25,000 fish. The Yakima Nation sought to enforce its in-stream flow treaty-created water right to protect what they called pulse flows down the Yakima River. Irrigators objected, saying you can't leave this water in the river to push fish down, because then we can't use our water right. And the irrigators lost, that in-stream flow water right that originates under the Stevens Treaties under federal law is an enforceable in-stream flow water right. And then finally, I'm going to skip to the Culverts case, which is a case pending before the U.S. Supreme Court right now. This is a case that started in 2001. Tribes sought to enforce their Stevens Treaty water right to habitat protection under the theory that culverts that blocked fish passage under state highways violated their treaty right. If fish can't migrate upstream to spawn because they're blocked by culverts, there are going to be no fish. If there's no fish, then the fishing clause of the treaties is not fulfilled. What the court said is this: the right of taking fish secured to the tribes imposes a duty on the state to refrain from building or operating culverts under state-maintained roads that hinder fish passage, et cetera, et cetera. If you take the holding of that case, that's the fundamental holding of that case, and you replace building or operating culverts with authorizing uses of water, it reads almost exactly the same. So read this slide, and then I'm going to replace it, the culvert clause, with uses of water. And you see my point. You can read the Culverts case to take the next step toward establishing an in-stream flow water right under the Stevens Treaties. The states appealed this decision. It's pending before the U.S. Supreme Court. States arguing that, as defined by the District Court and the Court of Appeals, it creates this kind of sweeping environmental servitude that could apply to shoreline permitting and water rights and growth management and things like that. The tribes view it in the opposite way, right? When the Orrick decision was vacated, the court said, we're not going to create this habitat servitude, but we will take on this issue when there is a specific applied claim of specific habitat damage. The tribe's saying, this is a specific example. There are specific culverts. We've identified them. They don't allow fish to move upstream. This is exactly what the courts back in the 80s said we should bring to the court as a treaty violation when it occurs. So whether or not the Culverts case takes the next step toward a broader in-stream flow water right under the Stevens Treaties remains to be seen. Very quickly, and we'll deal with it in questions, I hope. The legislature is spending a fair amount of time on Hearst. I think it's likely there'll be legislative action on it during 2018. To clarify the role of local governments under the Growth Management Act and as they issue building permits. but then at the same time figuring out what do we do about in-stream flows. There's going to have to be an in-stream flow restoration component to the bill because as addressed by the Supreme Court, there are lots of in-stream flow rules around the state where the flows are not being met. There's no impairment review of exempt wells and those flows are simply not being met. And then as to culverts, the Supreme Court could accept the appeal. If so, they'll hear it at the federal level in 2018. Exactly how that plays out remains to be seen. My observation on that is it's a case that started in 2001. If it gets resolved, it'll be in 2018, 17 years later, right? So the tribes have waited 17 years for resolution on the issue of should these culverts be removed or not. Even though it may create a powerful motivation for more litigation, is 17 years in federal court achieving the progress that they want to achieve on all sorts of environmental issues? I would argue not. If you look at Jay's example in the Yakima Basin, working together moves things along a lot more quickly than going to federal court. So even though there could be a victory for the tribes under the Culverts case, it may not necessarily move things along as quickly as some other alternatives might. So I think I'll leave it at that because I know I'm done with time and happy to take questions when we can. Thanks.
Thank you, Bill. And next we have Adam Gravely, who is a water rights lawyer in Seattle. One of the jobs I had before I was ecology director was one of the lawyers representing ecology, and whenever Adam's name showed up on the other side of a case, we were always intimidated and depressed. But he also, like Bill, brings a great deal of creativity and goodwill to the table, and we usually found our way to a really good solution. So, Adam.
So thank you very much for that introduction, Jay, and also thank you for the invitation to speak to you all today at another Whatcom Water Symposium that's covering a lot of really important subjects today. I'm going to try to give you a quick flyover of two legal authorities that are very much front and center in these discussions. First is a recent decision from 2015 of the Washington State Supreme Court. It's called the Foster decision. It involved the city of Yelm and a new water right application that they had submitted. And then the second legal authority is the Municipal Water Law enacted by the legislature in 2003 that we're still working through many issues on. So first, the Foster decision. The court in this case reversed the Department of Ecology's grant of a new groundwater right to the city of Yelm. And the actual holding in the decision is just that, and it's fairly straightforward. The interesting thing about the decision is how they got there and what this decision means for folks going forward. And this is very much still subject to interpretation, and we're working through this. But the basics of the case are that the city had put together an extensive mitigation plan to support their application, and it was a mix of what we call in-kind mitigation, which is what the court called wet water or actual water rights, and out-of-kind mitigation, which is a mix of land restoration, riparian acquisition to improve aquatic habitat. The water rights that were acquired in the mitigation plan were irrigation season water rights, and as a result, they did not account for depletions that were predicted by the groundwater model in the shoulder seasons, meaning the spring and the fall that are the shoulders, so to speak, of the irrigation season. And as a result, those minimum in-stream flow depletions were determined by the Department of Ecology to constitute impairment as they worked through the four-part test that Doug outlined for us when the department gets an application. And because of that depletion and the impairment finding, the department exercised its authority under what we call the OCPI provision for short, or the overriding considerations of the public interest. And this provision allows ecology to authorize quote-unquote withdrawals of water that would conflict with minimum in-stream flows. And the Supreme Court parsed the statute as follows. They focused on the term withdrawal, and they concluded that that term means a temporary authorization when the legislature uses that word, which is to be contrasted with the term of art for appropriation, which is the word that the legislature uses when they mean a permanent water right, like Jay and Doug were talking about earlier in the overview of Washington water law. And the court then drew on a comparison to the drought statute, which talks about preserving essential minimums during a drought, and the fact that that statute used the word withdrawal when it's referencing temporary authorizations that the department has authority to issue under a drought. But even in that circumstance, the department can't issue a temporary withdrawal that would impair or trench on those essential minimum in-stream flows. So the court concluded that OCPI does not authorize or not allow permanent impairment of minimum flows, which led them to the conclusion that they reached. So what does this mean going forward for this OCPI provision? The court has said in a couple of cases now that it requires extraordinary circumstances for the department to apply this OCPI provision, but they haven't really told us what that is. They've just told us a number of circumstances of what it's not. They did tell us in this case that the mitigation plan was irrelevant. So the city had prepared an extensive mitigation plan, but the court focused on the depletions and those depletions as being impairment. And the mitigation plan was not something that the court spent much time looking at. And so therefore the court disagreed with the department's judgment that the net ecological value of the application and the mitigation plan, when viewed as a whole, justified the permit. And instead they focused on the requirement to provide wet water to address any minimum in-stream flow depletions. So I think most folks are looking at this now and saying, as a practical matter, the OCPI provision as a tool, as a meaningful tool for the department to make decisions is now effectively closed. So the second subject that I wanted to cover very briefly today is the 2003 Municipal Water Law. And this law was controversial when it was adopted, and it continues to be controversial in some aspects today. But I included the bill title here because I think it's important to remember, okay, what was the animating purpose that the legislature had when it adopted this law? And so it had a twin purpose. One was to shore up certainty and flexibility of municipal water rights. A lot of questions had come up, a cloud of uncertainty had come over a certain class of water rights, and things were pretty frozen up. The other key purpose is the efficient use of water. And this bill actually gave joint or concurrent or shared jurisdiction to the Departments of Health and Ecology, with the Department of Health taking the lead on the efficiency purpose of this law. And that agency was directed to adopt rules which have been in place now for over 10 years. And these bullets are actually the Department of Health's summary of what the water efficiency rule has accomplished and requires. I can't say this for sure, but it's my impression that this rule is both the first and the most robust of its kind nationally. And I think this rule is getting pretty good reviews as we go forward. There's still work to be done, no doubt, but this has become part of municipal water suppliers' everyday business as they fold this efficiency rule and the measures it involves into their water system plans and their overall management of their water right portfolios to meet customer demand. So the other purpose of the law, the one that gets most of the attention in the courts and in conferences like this, are the water right certainty and flexibility aspects of the statute. And this was designed to address this uncertainty that had arisen about this class of water rights that are called system capacity certificates, or pumps and pipes water rights sometimes. And the administrative practice of the department over the decades was to issue certificates for these water rights prematurely. And so they had come up with some issues about their status, and the legislature provided in the municipal water law that these class of rights are, quote unquote, rights in good standing. And we're still trying to figure out exactly what that phrase means and how it operates in different circumstances. The statute also provided that ecology does not have authority to revoke or diminish a system capacity certificate, with three exceptions. One is after a change application, the second is after a general adjudication, like Jay mentioned in the Yakima River Basin, and then third, if there's any misrepresentation in the development of the water right. There's many provisions in the law, in this municipal water law. It's a long statute. It contains lots of different changes. Some of the other key provisions, though, that were essential in its development and also as it's played out in its implementation are to define for the first time the phrase municipal water supply purposes. And this is a very important term because, as Doug mentioned, water rights in Washington are subject to relinquishment under a 1967 law. But that law provides that water rights for municipal water supply purposes are exempt from relinquishment, but that law did not define what that meant. So we went for quite a period of time with controversy and uncertainty about which water rights were exempt from relinquishment under that municipal provision. And so for the first time, the legislature provided a definition. In addition, there had grown up a disconnect between the Growth Management Act and utility service areas on the one hand, and a water rights place of use, that legal description that Doug was pointing out on claims or certificates. There's been a disconnect there, and this law basically draws an equal sign between those two to say that your service area in your plan equals up with your water rights place of use. And then another important provision of the law was to codify in water utility law what we call the duty to serve, which is a water utilities obligation to provide service to a customer who requests it within their service area. And so there have been only a handful of appellate court cases so far that have addressed the municipal water law. The first decision was the Lummi Indian Nation v. Department of Ecology case, which was a facial constitutional challenge, which the statute survived in 2010. Then there was an appeal of a Washington State University water right transfer, where the court found that the university was a municipal water supplier, and therefore its application to amend its groundwater rights was approved. And the thing that I'll leave you with is that the next appellate case to weigh in on the municipal water law has just made its way to the Court of Appeals in Eastern Washington, where the court accepted an application for direct review of a decision of the Pollution Control Hearings Board in a case called Crown West Realty versus Department of Ecology. We don't have time to unpack this case. I'll just say that this is a case to watch. It concerns these cases always concern unusual and distinctive sets of facts that nobody could make up. It has to be reality. But this case involves a former Navy depot after World War II that then became a business park. There's a large water right associated with it, and there's a water right change application. And one of the key issues is this animal a municipal water right, a municipal water supplier, and are they able to go forward with the application that they have posed? So this next case, I would say, is the next appellate decision on this law, and no doubt will make some important law for us. So thank you very much.
How much time do we have for this section? 20 minutes? Okay. So 20-minute Q&A. Be thinking about questions that you would like to pose to these three practitioners. I have a few that I'm going to start with. Great. Adam, on the municipal water law, one of the concerns that I remember being registered at the time of its enactment and continues is it seemed that one of the purposes of the statute is to, as you mentioned, ensure reliable municipal water supply into the future. And a number of municipal water rights are very, very large and only a fraction of the rights being used. And typically, even with the relaxed rules that have been historically applied to municipal water right holders, at some point the department would say, okay, you've grown into your right, we're going to issue a certificate at this level. And the new law, as I understand it, relaxes that further and does give municipalities the ability to grow over long periods into fairly large water rights. And that caused concern amongst those who were waiting in line and folks who were worried about in-stream flows. But on the other hand, my impression is that through the conservation and efficiency side of the statute, municipalities have been able to increase the number of connections and increase the number of folks that they're serving without really increasing the amount of water that they are withdrawing or that they're diverting. Can you talk about that on the conservation side? Is my impression correct that there is a pretty impressive record of the accomplishments of conservation?
Okay, thanks, Jay. There's a couple questions there. So just to start with the municipal water law and where it connects on growing into those rights, the one thing that I wanted to mention is that there's a statute that's in the water code, I I believe it's 9003-247, and it requires all water rights to be developed with reasonable diligence. And this requirement to continue to develop a water right with reasonable diligence, this was developed during the briefing in the case law in a couple of the cases that I mentioned, that requirement still applies to municipal water rights, including inchoate water rights, the category of water rights that we're talking about. So the basic principles of of water law that apply to the development and perfection of a water right continue to apply here to this special category of municipal rights. The statute was intended, I think, to just fix this sort of 100-year administrative error that the Department of Ecology had made. So I don't have sort of categorical information for you here about the success of the conservation and efficiency, but I know, for example, that particularly large cities that have a lot of resources to bring to bear on conservation programs have had great success in basically keeping their water supply numbers flat while they continue to serve large numbers of people. I guess I would just make two other sort of general points here on this topic as cities and other municipal water utilities look out into the future. Two things that I think are starting to kind of take hold in the mindset. First is the kind of concept that there are no more new water rights that are generally available or that are going to be issued. So I think utilities are increasingly considering the set of water rights or the portfolio of water rights that they have at this moment to be all that they're likely to acquire forever. And then secondly, when you look at the population growth forecasts at our state and the population that's expected to come to our state and grow here over the next few decades, it's an immense number of people that presents a great challenge to municipal water suppliers about how this growth is going to be met. So there's a lot of challenges here, but I think we've got a couple of building blocks with this statute.
Okay, great. And Doug is the representative of the agency that has to administer this system. The problem that Adam just mentioned of increasing numbers of people, numbers of amount of demand on these various water rights and municipal and other and individual water rights, and the fact that we're already challenged in meeting in-stream flows. They're established by rule. And then you throw on top of that the widely held perception that we're likely to have less snowpack in the future, more precipitation falling as rain and running through the system. That sounds like a dangerous recipe of factors kind of coming into conflict with each other. What are your thoughts, and what are, if you can describe for us what the department's position is with regard to how do you, as the administrator of this system, reconcile and manage the need for reliable water supply for all sorts of uses with always increasing demand and the potential for dramatically different hydrologic regimes? There's a big one for you.
Yeah.
Well, you know, in the past, we've often, when municipalities or water systems come to us with saying we need more water, or we're exceeding our water right, or we bring it to their attention that they're exceeding their water right, the assumption is that we will find a way to fix it. And I just think that's a risky assumption, you know, as we go on. But we do everything we can to try to find ways to help them conserve, help to manage their water, or find creative ways to get additional supplemental water, alternative water supply. And some of that is not really finding new water, but the shell game, moving things, it's not really a shell game, but moving things around so that where we have water rights that we can transfer and help them with, we do that where we can. But there are no easy solutions.
Bill, you can tell me.
And just the one thing I was going to add on the in-stream flow issue is, you know, I showed the slide of what the minimum in-stream flow is, and the fact that the actual flow a lot of times is about half, right? You're not close to meeting the in-stream flow, but I would not let that meeting the flow or not meeting the flow define success, right? Because you look at the flow versus the actual number, you're not going to meet it. You can't meet it, but can you make progress toward it? And can you do things like helping tributaries? Because a little bit of water in a tributary ecologically can be a lot more valuable than a lot more water in the main stem. And so don't necessarily, as you go down this road here in the Nooksack, don't necessarily look at if we're not meeting the in-stream flow, we're failing, right? The question is, are you making progress toward a better ecological outcome? And it may get you closer to meeting the in-stream flow. You still may not meet it, but you're still making progress toward a better overall situation.
We have an MOA with the city of Linden. We've been working with them for 20 years to try to get their system to where they have adequate water rights, and particularly their QA is their problem. And we've made a lot of progress, but it's been really hard going up there. There's not a lot of readily available new water.
Okay, audience members. See a question right there.
I'm Eric Hearst, but my question is not about the Hearst case.
We have a celebrity in our midst.
Adam, I'm a little skeptical of your claim that the Department of Health mandated water use efficiency programs are having all that success. But regardless, the biggest water user by far in the state, and the one that's most important during the critical summer months, is agriculture, irrigation. How come the state has no programs to encourage improvements in agricultural efficiency? As far as I know, neither Ecology nor the State Department of Agriculture has any kind of formal program to encourage farmers and help them to use their water more efficiently.
And I'm happy to touch on that too. Eric, first of all, it's nice to meet you after all these years.
You wouldn't believe how many people talk about you in Olympia.
Yeah. No, people are like, who's this Hearst guy? I said, I get emails from him once in a while. So, yeah, nice to see you. I think in contrast to the municipal world, there's not necessarily a statutory program, but through the years, there's been a considerable amount of funding through the capital budget, ironically, this year, to make irrigation uses more efficient. The funding's been sporadic, but if you look at what Ecology has done, what Department of Agriculture has done, there's been a lot of work on irrigation efficiencies through conservation districts and others. You may not see it as a statutory requirement, but there are in fact programs to do it.
Doug, you want to?
Well, yeah, one of the developments we've seen over the last 20-plus years is in Whatcom County is a conversion from certain kinds of crops, corn or hay, to berries, right? A lot of berries, and to make that change, most of the operators, probably all of them, have gone from broadcast irrigation to drip, and so they've become more efficient. A lot of the stuff that you're talking about isn't of that kind of improvements in efficiency is not apparent on paper, but it's there. So that's one of the challenges we have, is to try to take all that and figure out what does that mean in the long term with water that's available to do other things with, or looking at some of the unpermitted irrigation that goes on as ways that we can take the water that we already have and make the best use of it and the most efficient use of it. And I think a lot of progress has been made, but we still have work to do.
Adam.
So I wanted to speak to the municipal water efficiency point. I think the point is not that the Department of Health regulation or the Municipal Water Law has completely addressed water conservation and efficiency and the problem's all over. That's not the point. The point is that significant progress has been made and we appear to be moving in the right direction, but the problem is immense. And the bigger problem really is this aging infrastructure issue that we have nationally, where we've underinvested for a period of decades in our water infrastructure writ large, right? Wastewater systems in addition to water supply systems. And so utilities have been deferring maintenance for a long time. And so if we're talking about bringing funds to an issue, there's a lot of progress that could be made in this area if we were to invest in water infrastructure.
And I would say, in my experience with stream flow restoration and ecosystem restoration projects mostly happening on the east side of the states, where there is almost always a significant agricultural water use component in the basin, a pretty high level of efficiency is is just sort of an assumed price of admission in some ways, and it oftentimes is funded at least partially through public funds. You're right, there's not a set of agricultural efficiency standards codified in a rule, but there are pretty well accepted standards for conservation. And if you're in a basin where there is an effort to restore flows and you're using most of the water for out of stream use, and you're not meeting a fairly high level of efficiency, I don't think that's going to fly. So I think that is commonly part of the recipe of actions to improve the water right and the flow situation. Okay, next question. Yes.
We hear a lot about the legal aspects of the Hearst decision, but I haven't heard anything about methodology on measuring how wells can affect in-stream flows, the tie of groundwater to surface water. There's a lot of technology out there. I don't hear anything about it. Why is that? It's all the legal stuff, but what about the technical stuff?
Well, us lawyers really like to talk about the legal stuff. But Doug, do you have a response to that?
So to be able to show that your withdrawal of water for your domestic use with a well, and to show that that's not affecting any surface water that's flow limited or seasonally closed or just closed because of the rule, is really difficult. And in some cases, in other cases it's not, but in most cases it's pretty difficult. And there are some very smart people in this room that have been trying to help come up with approaches to that, where there's something that they can provide to the county that makes sense, that helps them frame the question, and maybe in some cases be able to show that it's not going to affect a surface stream. But it's tough, There's no simple way, and it's probably going to cost some money. But I don't know if the counties even they haven't received many of those because we have a moratorium right now. But other counties are addressing that, and so I don't have any simple answer for you. No easy solutions.
My reaction to that is you're absolutely right. There's all sorts of existing technology and innovation that could help us understand better the connection between groundwater and various aquifers and a surface stream. I personally feel like, from everything I know, and I'm not a technical person, I'm not a scientist, but what I've seen is it should be, I think the science supports the notion that most groundwater is in continuity with a surface stream. It might not be the closest one, but it's likely in continuity with a stream. If it's not the closest one, it's the next closest one. I think the place where there might be an opportunity for accessing groundwater in a way that doesn't adversely impact stream flows is in a relatively narrow band of properties that are relatively close to marine waters. So you're in continuity, but you're in continuity with marine waters and not with a surface water stream. That's my guess, is where if you can get new groundwater and get a water right for it, that's probably the location where it could be done. Yes, question back there.
But if we cannot prove that a well, for instance, the negative end of it, how can you prove the positive end of it? If there is no proof that a well that doing such and such will resolve your problem, how can you prove that the well created the problem?
And this is probably our last question, just to let folks know.
We can focus a lot on how many molecules of water are affecting what stream, and I think in the long term, maybe that's not really going to be the solution that helps get us there, that helps get answers and get people the water they need to build their home. It may be more about water availability of water made through some banking system or mitigation or other ways that we can go about trying to find ways to have water that's available based on some existing rights and ability to move some of that around.
Typically, I think that's the case, right? And the challenge is the way most groundwater models are done, and Chuck or others can correct us later in the day, because, you know, the attorneys love to be the hydrogeologists and vice versa, right? I've noticed that through the years. Models tend to over-predict what the impacts are, and that's just the way the models are typically created. You know, my view on it is, if we're spending time and money focusing on one well and the impact of one exempt well, I think we're not focusing the resources in the right way. The way I would look at it is, look at the county's land use pattern, any county, and you can look at where the lot's situated, which of those lots can be further subdivided, how many wells will that create over time. If there's a certain density of lots and therefore wells, you may have a cumulative impact that is worth taking a look at and doing something about. If the wells are widely spread, there's probably not an impact that you can really trace. You still need to do something about the overall consumptive use increase, but it's probably not worth spending money to investigate the impacts of one well and try to prove or disprove what those impacts are. Because you're spending a lot of money not doing something to put water back in the stream.
Okay, people are getting warmed up here, so we're going to take a couple more.
Hi, Dirk Nestor from Custer. I had a question regarding the 5,000 gallon exemption. Today, could I go home, dig a hole, and extract 5,000 gallons of water to water my garden and livestock?
You could physically do that.
Can I legally do that?
You know, the Hearst really focuses on building permits. So I think that question is still open, and until somebody says, no, you can't, I'm not sure that we can say you can't do it. It's still, the exemption is still strong in this case. So maybe these folks that know more about the legal stuff than I do, but my understanding is until there's a case, a decision made by a court that says you can't do it, it's still exempt.
Yeah, I mean, I think it's kind of a mixed, I'd give a mixed answer, which is, if you're drilling a well for purposes of getting a building permit from the county to build a house, I think the answer is no, because under the Hearst decision, the county now has to review that well for impairment. And under the current situation, at least within the Nooksack Basin, the answer is that's not an adequate water supply, you can't get a building permit. You can drill the well, you just can't build the house. As to other exempt uses like stock water, there's nothing in the Hearst decision that relates to stock water. So for example, you could call a well driller, the well driller could come drill a well and use it for stock water because there's no interface with the county's land use authority. So it's kind of a mixed question as to what the purpose of that well is.
And could there be impairment of a stream by doing that? Yeah, there could be, and there may be, probably is. But in our rule, we did not address exempt wells specifically. We said to get a permit that you had to determine that it wasn't further impacting a stream. We didn't really call out exempt wells specifically, and that's one of the things we said in our brief on the first go-around of the appeals. But in the Hearst case, they said, you know, for the purposes of growth management and building permits, that doesn't matter. Impairment is impairment. So it could come in the future. So, you know.
I think it would be a risky step, personally. And I know we have a bunch more questions, but I'm being told we are out of time. So maybe you could talk to some of these folks or me after this session, but we need to move on to our next session.